just appeared at the courthouse behind me, which is Tamworth Local Court, out in the rural area, rural western country town of New South Wales, the capital of country music in Australia. And I don't usually get out here, but when the call comes through and client wants me to come out and travel to represent them, certainly I can do that to any courthouse around New South Wales or Queensland for that matter. This matter involved a middle range drink driving offence, 0.116. It occurred in Wagga Wagga. Our client is a young 21-year-old student who is studying agriculture, and he was desperate to be able to avoid a criminal conviction and to avoid the mandatory alcohol interlock program. He contacted us early in the piece and wanted some advice and some strategy surrounding how best to handle his matter. We went through and explained everything to do with the law, what to expect, how to best prepare his case, and the likelihood of the outcomes that he could expect before the court. So what we did is he engaged us. He was happy to engage us. We got the matter, which was first listed at Wagga Wagga Local Court in the area where the matter had originally occurred. We got the matter adjourned and transferred up to Tamworth Local Court, where I am currently at the moment. The reason why we did that is because he was actually in Wagga Wagga attending a agricultural ball event. He doesn't live there. He doesn't live anywhere near there. He was just visiting the town at the time, and we did want to get the matter transferred up closer to where he's currently working. He's working on a farm out at Spring Ridge, and Tamworth is about 1 hour's drive, 1 hour and 15 drive from Spring Ridge. So this was the closest major court to where he's currently working. We were able to get that matter adjourned. We entered an early plea guilty at Wagga Wagga Court. We were able to get the matter adjourned and transferred to Tamworth with no problems. Our strategy was to get quite a lengthy adjournment because he was put off the road at the time of the offence. So his ultimate goal was to avoid a conviction and avoid any interlock order being made. Now, as I explained to him, this is often an extremely difficult outcome to achieve when the blood alcohol reading is in the mid-range category, and certainly his matter was not at the bottom end of the middle range category. It was well into it, probably in the middle of the middle range category at 0.116. So very difficult outcome to achieve, and I naturally had to explain to our client that this would be it would be an unlikely outcome to achieve this, but in the same vein, what have you got to lose? You've got to prepare a case a proper way. You've got to put every steps in place, do all the right things, get all the right material, present the case the right way, and push hard for the best outcome you can possible. Because in my view, if you don't go in there fighting for it or ask for the particular desired outcome, then the court won't consider it. But certainly by way of client expectations and management, I did make him aware that for the most part, asking for a no conviction for a middle range drink driving offence of 0.116 would be unlikely. But that was fine. He was happy to proceed and listen to our strategy. So we did get the matter adjourned. We got a lengthy adjournment, and the matter was here before court today. He was suspended at the time of the offence. So as of today, he's currently been off the road for 3.5 months. And this was something that we could tell the court that we weren't coming to court today asking for a no conviction and trying to escape all penalties. He's actually been put to a level of punishment by already being off the road for 3.5 months. So it was a bit of a sweetener in pushing the court to use their discretion not to record a conviction. I mean, the facts surrounding this matter were basically that my client and his girlfriend, as mentioned, had attended Wagga Wagga for a black tie agricultural ball event. They consumed quite a lot of drinks throughout the night. They were staying at a hotel in Wagga Wagga. My client had his last drink at about 12 or midnight, and went back to the hotel. After being there for a couple of hours, he and his girlfriend were hungry. He decided to get into the car, drive a short distance down to the local service station to get some late night snacks. Police pulled him over and they mentioned that he was driving without his headlights properly illuminated or activated, and that gave him them reason to pull him over. He pulled over as he was turning into the Caltex police station. He was roadside tested. It was a positive reading, taken back to Wagga Wagga police station and delivered a final blood alcohol concentration reading of 0.116. So very, very comfortably in the middle of the middle range category. Our client was shocked. He was remorseful, showed immediate regret, and cooperated with the police. So that was the charge. He's got a very good record. He was on a Western Australian licence, but despite that, he was suspended from driving in New South Wales from the time that the offence was laid on him, the time of the incident. He is from Western Australia, has a Western Australian record. He's only still relatively young, 21 years of age, and he has a very clean record. He's got one more minor speeding infringement, which occurred 3 years ago, but otherwise no criminal record and no other traffic record. So it was able to give us the ammunition to say to the court that this was certainly out of character for him and highly unlikely that it would be repeated again in the future. We got him to do a traffic offenders program. We had the completion certificate and the reflection material to tender to the court. This showed a willingness for him to re-educate himself on driver safety, so that was taken into account. We also had his college tertiary education college principal provide a letter of reference and provided his academic transcript from last year, which showed all very good results. He's clearly a good young man with a bright future ahead of him who has made this very foolish and silly one-off mistake. We got his grandfather to provide a letter of reference, and we also helped him put together a very good and strong letter of apology to the court, showing very good insight into his offending and how deeply remorseful he was over the entire matter. The court, the magistrate today, was almost torn about what penalty or result to give our client. Certainly the prosecutor got up and was very strong in their submissions to say that the court should not deal with our client by way of a no conviction because of the reading and because he was brought to the attention of police through his manner of driving without the headlights attached. So that was the that was the case that we presented before the court today. The other thing, the big kicker, was that he's currently doing a work placement on a farm at Spring Ridge, and his boss has indicated to him that if he was subject to a mandatory interlock order for the next 12 months, then he would lose his placement at that job, because his boss was not willing to put an interlock device into every vehicle on the farm operated by 14 other staff, and as a result he would have lost his practical workplace placement at that farm, and that would have had significant implications on his studies. It would have put him back by about a year, so that was certainly another thing taken into account by the court. The balancing act by the court was to decide whether, due to the reading and how comfortably into the mid-range it was, that the court had to send a message of general deterrence to the rest of the public that you just cannot get away with mid-range drink driving or any sort of PCA drink driving offence. But the magistrate was also torn between the fact that our client was a young person of very good character, was going places, had done the traffic offenders program, and shown genuine remorse, insight into his offending, and had the effects that it would have on his current workplace. The magistrate only just fell onto our side and decided not to record a conviction, and placed our client on a conditional release order, which is like a good behaviour bond for a period of 12 months. So I'm very, very happy and elated client today, and that was the matter we had out here at the lovely Tamworth Local Court, and thanks for tuning in today. I want to thank you for tuning into Boorman Lawyers today. You can catch us at any of the usual social media platforms. Please subscribe to our YouTube channel. And if you've got any questions or queries, please don't hesitate to contact us on 1300 941 900. Hey guys, thanks for tuning into this video today. I really hope it was informative and helpful for you. There's another couple of videos below that you might want to check out that may be very useful for the process that you might be going through at the moment. Please feel free to like, follow, share, and subscribe to our YouTube channel, because we've always got fresh new content coming through all the time.